I don't know. After hearing him calm and talking about the tether story, it's probable.
Go down to the county attorney's office. I think you'll find a lot of humans down there.
All right.
No disrespect.
Stop driving.
I'm flirting with the judge in front of my dad.
Probation. Wow, what's going on? This is Colin. How's everybody doing? Happy Halloween. Didn't really think of the timing of this because my kids live in Houston and I don't. So I'm not doing anything with trick or treating. I'm just waiting for pictures from them. That's it. So didn't really think about everyone else having plans. So everyone that is here, I appreciate you coming and stopping by. I did just hit 6,000 subscribers. So thank you all so very much. It's been fun. It has been a lot of fun so far, and we're just still continuing to grow. I didn't think I was going to be growing much at all once I was demonetized, and it's still going. So I love each and every one of you, and thank you so much. Even the people that don't really like me too much. You guys are okay too. All right, I've got a good one. Judge DiSanto today. This guy was in one of my videos about a month or two ago. I tried to find the clip because I wanted to play a portion of it before this, but because I had so many clips to one video, I couldn't find it. I spent maybe an hour clicking on every one of my videos, going through them. Problem is, I've got almost 200 videos, so it takes a long time to go through them, and I just couldn't find it. So if anybody can find that clip and let me know what video it is, I want to add the link to the description. But this guy was in court before, same attitude problem, still yelling at the staff. Judge DiSanto's still not happy about it. And this isn't any better. So let's get into it. But before I hit that play button, you know what to do. Like and subscribe, please. And do your jump kick backflips if you want, if you haven't already. You're going to need to after you eat all that Halloween candy. And if you would like to, donate to the demonetization fund, the Colin, I don't remember what we renamed it. I really don't. Tired. I'm sorry. The link's down there. It'll be in the chat as well. You can donate and say happy 6K subs. That would work too. All right. Let's go.
092.
What was the case number?
212092.
Good morning. Good afternoon, Your Honor. Mr. Shepke, appearing with my client who appears via Zoom. After he makes his identifies himself, I have a household condition.
All right. And sir, your name for the record, please.
Donovan Dupre.
All right, thank you. And I apologize for your wait this morning, sir. And you said you had a housekeeping issue, counsel?
Yes, Your Honor. I understand that my client is off probation and that he's getting restitution from an individual by the name of Anthony Puhl, P-U-H-L. When he mentioned that name, it was a name that was familiar to me. I did represent Anthony at the beginning of the year. I believe our last court date was approximately February. I did bring this to the attention to my client. I asked if there was a conflict. I don't particularly have a conflict. It was a court-appointed case. It didn't provide me any sort of issue, but I wanted to make sure that my client was aware. And at this point, if there still is no conflict, I'd asked him to put that on the record that he has no problem with me representing him for today's proceeding.
All right, Mr. Dupre, were you able to hear that?
I did hear that.
Okay. And do you have any objection to
I have no
Mr.
objection.
Shumke continuing to represent you in this matter?
Yes,
You have an objection for Mr. Shumke to continue to represent you in this matter?
I'm sorry. You may.
Do you have any objection to Mr. Shumke continuing to represent you in this matter?
I have no objection.
Okay, and so this is a show cause today because Mr. Dupre has been ordered to cease communication with the court other than asking a question as to whether or not Mr. Puel had made a restitution payment and when it was made. This occurred due to the volume of communications from Mr. Dupre, as well as the tone of the communications from Mr. Dupre. And that was on July 19th of 2023. Since that time, there's been a number of communications from Mr. Dupre in violation of this court's order. And so that is why this court, that's why a show cause was scheduled as to why Mr. Dupre should show cause as to why he should not be held in contempt of court. I understand that Mr. Dupre wants information regarding the restitution, and he has accused this court of not sending him his restitution upon receipt. This court has previously informed Mr. Dupre in writing through staff members as well as on the record that depending on when the restitution payment is received, then the restitution will be sent to Mr. Dupre. Those are sent out one time a month. There was 1 month that there was a restitution not sent to Mr. Dupre. Both were sent the following month. And Mr. Dupre seemed to take issue that was not done because there was a vacation that somebody was on. Since then, Mr. Dupre has not followed this court's orders and has continued to contact the court with multiple messages, sometimes the same message 5, 6, 7 times in a row, as well as communication beyond whether or not a restitution payment was made or not. And so, counsel, I just wanted to set that for the record.
Yes, Your Honor. When I spoke with my client regarding this, he indicated that I believe he had some ambiguity because he thought that he could have contact with the court. And when I discussed that with him, I think that he was unsure of the nature of what kind of contact he could have. But I mean, at this point, since we are here, obviously the point of the show cause, he did wait patiently. I think that it would, on the record, my client being so advised, the level of contact he can have, the nature of what he can have, without any ambiguity. I don't believe that my client wishes to knowingly or maliciously violate any court orders. Obviously, he's in a position where he is still out a significant amount of money, and the restitution is very important to him. I'm sure that sometimes that leads him to frustration. But during our dialogue, he was polite, sincere, and contrite. And it's my hope that potentially misunderstanding can be solidified today into a knowing agreement that could be made by my client as a promise to the court to not have any further issues. And my client very well might want to address the court, but it's my hope that this matter does not have to stem into anything worse.
Mr. Dupre is ready.
All right. I don't know if you remember in the first video. I don't know if you guys even remember the first video. Like I said, it was about a month ago, maybe a little bit longer. I'm not sure. His restitution from the court is $20 a month, $25 a month. They didn't explain why he was getting restitution from the court, but he's owed $20, $25 a month from the court. So whoever's paying him restitution, that's how much he gets from the court. Now, in his first appearance, he was arguing because there was some issue where 1 month he didn't get his check for $25, and he was going off on the court staff, which is why he was in front of the judge. He was in front of Judge DiSanto for yelling at the court staff, accusing him of a bunch of different things. So during that hearing, Judge DiSanto said he's no longer allowed to talk to anyone in the court unless it specifically had to do with his money, and that was it. He wasn't allowed to say anything else. That was it. That was the only thing he was allowed to do. Now he's in a show cause hearing right now because he continues to harass the court for his $25. And I'm not saying that's not important. It's money that's owed to him, and I get that. But treating people poorly over $25, I mean, I don't know. Now maybe I'm sounding bad because I'm making it $25 not sound like a lot. I don't know. I don't know what his situation is. It's a lot to me. I don't have a job right now. This is what I do. So I love $25, but I wouldn't yell at somebody over it. All right. Sorry, long pause. All right, let's go.
Anything that you'd like to say? Your attorney indicated you may want to say something to the court.
I have not only just made an agreement, I have not only offered an agreement to have no more problems, I've also agreed to, within 4 or 5 months, pay off my charges completely, have absolutely no more contact with this court at all, be done with the state of, the county of Wyandotte or the city of Wyandotte, whichever it is, or both potentially, completely. I don't even want to be back in Wyandotte due to the fact of how how the police department runs their own department. I'm sincerely apologizing if anybody took offense to what I've had to say. It's also come to my attention that this court, specifically, I believe the probation department, has been giving out false numbers and communication methods to my defense attorneys, as has just happened today with this lawyer today.
False numbers?
The number that I didn't say that I was received false number, the number that I most recently had from him, he indicated to me was not an accurate number, and then I was willing to give him my phone number so that if there was any further communication, we could make sure that I was readily available at his needs. But I don't believe that there was any malicious intent by probation to sidestep our communication, and I was very glad to have the opportunity to speak with him today.
All right, thank you. And so, Mr. Dupre, I understand, or Mr. Dupre, I understand that you changed your number, correct?
No, I have not.
You have not changed your number at all since your case began.
No, it has been 734-666-8168 the entire time.
You put your number on the record right now, but, okay. And so if there is a number that was provided to Mr. Shumke in error, sir, I can assure you it is not done with any malicious intent. I can also assure you that the staff members here, all of them, work very hard. And you may disagree with that because you're not receiving your restitution payments. However, the staff members work very hard. They do not need to be susceptible. They do not need to be in receipt of any harassing or threatening communications, whether via email or via phone. Just a moment, sir. The restitution payments that have been paid have all been sent to you. There have not been any further restitution payments that have been made. There is a procedure pursuant to statute that Ms. Shaw has followed. And so from there, she needs to send notice to the prosecuting attorney. If the prosecuting attorney then wants to proceed in accordance with the statute, that is how that will go. I understand that it's a good chunk of money and that you would like your money paid to you. I don't disagree with you, sir.
Wyandotte 27 District Court has left the court. I'm sorry, I cannot hear you whatsoever.
All right, a lot of this isn't my fault. There was some connectivity issues on the court. The court just dropped out of the call, so that's what just happened. The little spinning wheel thing, I was trying to switch headphones and trying to mute at the same time because I knew his number was coming up. Now I got to go back and remove it from the video. So nobody call that number, please. I think it actually did clip out when he was saying it. So I don't even think we heard it. But I got to go back and watch it. But like I said, a lot of this isn't my fault. It's just the court. And we have another few.
I don't even know if you can hear me at this moment.
This is not the Trumpster guy. Someone asked that question a minute ago. It's not the same guy.
I'm deaf.
Hey, me too. I'm actually legally deaf, though. You're just dumb.
Okay, so our audio had gone out, so I stopped talking, sir, because I knew you wouldn't be able to hear me. And so I was very clear that in the event you had any questions regarding your payments that you needed to file a motion, put it on the docket, and you could address your issues that way. Due to the tone and volume of your communications with the court. That being said, now that you are more fully aware and it is more clear to you, I'm going to presume, with what the limitations are and how you can have any issues regarding restitution addressed, the court will adjourn the show cause Do you have your January calendar, council, or no? Okay. Do you believe that you're on Mondays in January?
I know that if I were to be on a Monday, I actually did put a case, yesterday's case, onto a January 22nd day. So since I'm already going to be on, I have to do it that day, which is a Monday.
All right, we will adjourn this to January 22nd at 10 a.m.
And one housekeeping issue, one thing I noticed, Judge, when preparing the docket, I could see why I wasn't able to speak to Mr. Dupre. Beyond just a phone number is listed as non-public because of the vision that he's had and the availability of the statute. So I would never be able to even see that he had the case, but for it being handed to me today. But now that I did take down his number, I'll make sure that I will reach out to him if he has any questions or concerns.
Okay, and we also have his email address that if in the event you need to, if you need email and if the form doesn't go through. Anything else?
No, Judge.
And Mr. Dupre, you had your hand up. Anything else?
I just wanted to also ask, why is it when I put in $240 for my last payment for my last charge, was it this court commit larceny to put it somewhere else completely, up until the point where I've had to contact this court to have it directed somewhere else to the correct spot?
Okay. All right. First of all, sir, the allegation of the court committing larceny, I don't believe is accurate. You're saying it was put somewhere else? What do you mean?
If you take $240 that I paid, and I paid online, and I had specific instructions to go towards one charge, and you put it towards another, that is stealing funds and putting it towards somewhere I didn't consent for it to be. By definition, that is larceny.
Their funds were not stolen from you. It's possible.
Yeah, until I had to contact about it.
Sir, it is possible that a mistake was made and your note about which file that was to go on was not received. I don't know.
So you can receive my payment, but you did not receive the amount.
That doesn't mean that anybody stole money or committed larceny. Your money was applied I will make sure that our newer employees that are training have the information as to how to note that there are notes into which file those go on.
Okay.
Further, if there are multiple files that, or multiple cases that you have, and a payment is made, so as to not have one file go into warrant status for non-payment, sometimes payments are applied to both cases. That is actually in your benefit, sir. But in the future, if you would like to only have payments made on one case and not another, so that matter goes into warrant status, then we will be happy to oblige with that, if that's what you would prefer. Now, furthermore, please make sure when you're making your payment, you are putting the case number and not the ticket number.
I have an entire screenshot of me filling out everything that was on that application online, and it is all filled out 100% and 100% correct. The only fact that it has been placed anywhere else is because your staff has placed it somewhere else. Under completely ignoring the note that is said and has been completely filled out 100%. You guys went completely against that.
Sir, the information that we had was your ticket number, not your case number.
And I
not
put
the
both
case
down.
number. Well, for some reason, when that was processed, the case number didn't show up, only what you wrote is your ticket number. So the ticket number is not necessary, just the case number.
Well, I put down both. So why wasn't either read? They should have been confirmed at least twice before you put my fundings anywhere.
Sir, there may be a limit as to how many characters are submitted through to the court on the part of the third-party processor for the credit card payments. If that is the case, perhaps the case number didn't make its way through.
There's separate spots for both.
What I'm indicating, sir, is that make sure that your case number is on there, as you've indicated that you did, but make sure it's the case number only and not the ticket number then.
Thank you, Judge.
Thank you. All right, have a good day.
When is this adjourned to again?
January 22nd at 10 a.m. Do not have any further communications with the court other than filing a motion. And you remember what I said, so. All right.
Yeah, that was fun, right? That was fun. That was a lot of fun. I see a lot of comments about not being able to hear. No, I actually, I know a lot of people are saying that they're, percentage deaf. I'm 100% deaf in one ear and partially in the other. So I can't hear without headphones. It's very difficult, and it's only from one side. It doesn't matter where your sound's coming from. I always think you're on the left side. So that is legit my hearing. It's been that way since birth. I don't know if I saw any other questions, but yeah, that guy was a jackass. And for anyone that came in late, I did have a video on him about a month ago. He was in court. He was in person saying the same thing, being in trouble for yelling at the staff. So you guys heard that. Hey, Biggin's here. Welcome, Biggin. All right. I don't really remember what the next case is, but I believe everything came from today. So yeah, let's have fun together. This
all right.
This one is gonna make you guys mad. I'm gonna warn you right now. You're gonna be mad. She doesn't have an attitude problem. She has a lack of responsibility problem, and just to warn you, yeah, okay. Now that I've warned you,
So do we need Miss Tolles anymore?
We don't need Ms. Tolles. That's what she does. No, Your Honor, we don't.
All right. So Miss Tolles, you're free to go if another court needs you. Thank you. All right. So Miss Aldridge, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right. You can put your hand down. Ms. Aldridge, you're before the court on 2021 CR 04484, Mary Nell Aldridge, for driving under the influence, count 1 per se, driving under the influence less safe, count 2, an open container violation. You're represented by Attorney Justin White of the law firm of Lister Holton Dennis. But Mr. White, what is your client plea to the offenses before the court?
Your Honor, she'll be pleading guilty to the DUI per se, as well as the open container, Your Honor.
All right. By entering a plea of guilty to counts 1 and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes.
All right, factual basis and recommendation, please.
Your Honor, Mr. White, I don't think you said, which one were you taking?
He said driving
And
under
I-
the influence per se and open container.
Oh, no, Your Honor, the offer.
Yes,
Oh.
Your Honor. We had discussed multiple different offers in the case. Ms. Aldridge has decided to take the offer that was $800 fine, 60 hours community service with the 1 AA meeting per week.
Okay.
I emailed you something, lawyer. I don't know if you got it already, but I did go to a DUI and DDS school. I don't know how much of a difference would that make in the offer you all are trying to give me.
Okay, I thought y'all talked about this.
All right. You're right, Northwest. I don't know why I'm putting 2 links out there when I could just add Discord to my link tree. This is why I need smart people around me. Even though I think I'm pretty smart, having smarter people around you, it makes you better. Yeah. What else was I gonna say? I already said hi to Biggin. I guess yeah, let's just keep going. Oh yeah, that's what I was stopping for. Melanie, thank you so much for the super chat. $10, I very much appreciate it. If anyone else wants to donate to the, I don't know, I never remember what we renamed it, support Colin fund because I'm demonetized. I don't know. All right, the link's somewhere. It's in the description. It's floating through the chat. All right, sorry. Let's go.
All right.
Yes, we did, but I don't know if you got the email quick enough. Yeah, I did a DUI and DDS at
It's not for me. It's not going to matter. It's for me anyway. Thank you. Okay. All right, Your Honor, on December the 4th of 2020, during a road safety check, where the officer, was on, let me probably check out, I had that sleeping sheet already. Norman Drive and Park Place, where the incident occurred in Clayton County. He came into contact with a motor vehicle being operated by the defendant, Miss Mary Aldridge, where he took her driver's license and confirmed through a GCIC check. At that time, the officer observed a strong odor of alcohol coming from her breath, and then observed an open wine bottle in the cup holder. Upon stepping, the officer asked the defendant to step out of the vehicle. Upon stepping out of the vehicle, she lost her balance. The officer asked her how much she had been drinking. She said a few glasses of Chardonnay, but she was not drunk. And advised that she was on her way to pick up her children. The officer asked the defendant about conducting the field sobriety test, in which she agreed. At that time, he performed the HGN, the walk and turn, and the one-leg stand, to which the defendant did not perform well on either of those tests. At that time, the officer took the defendant into custody, read her the implied consent. She consented to giving her blood. Blood was drawn. And it was 0.121. The blood alcohol content was determined to be 0.121. So for count one, the state is recommending 12 months probation, a $800 fine, 60 hours of community service, a risk reduction program, drug and alcohol evaluation and follow-up treatment, no drugs or alcohol, random screening and testing, and 1 AA meeting per week. Count two would merge, count three be a $200 fine.
All right. Mr. White?
Your Honor, that is what we negotiated. The only thing I would ask is that due to the extra conditions added on to the DUI, if we could just suspend the open container fine. Your Honor, Ms. Aldridge is taking care of her kids. She's going back and forth between Georgia and Miami to help to work, and she does not have stable housing, completely stable housing at the moment. So we just ask at least, very least, that fine be suspended, Your Honor.
All right, so, any objections from the state?
The suspension of the fine, Your Honor?
The $200 fine.
Well, yes, because we got down to these numbers as a part of the negotiations, so I do, but you know.
All right, so that'll be in the, okay. So, Mr. White, the one consolation is, the number 3 won't have the additional, DUI fines with it. Sometimes if you say $1,000 on the DUI, you know how the fines are enhanced. So, the $200 will be at the regular rate.
Yes, Your Honor.
All right. So, Ms. Aldridge,
Question. Oh, go ahead.
I'm gonna explain everything, and if you have questions after I finish, then you can ask. All right, so 12 months probation, a fine in the amount of $800. It's gonna be a lot more than that because of the surcharges. I have the regular surcharges, but I don't have the DUI enhanced surcharges. But there's more if it's a
More
DUI.
charges? It's crazy. I don't even have nowhere to stay. Like, well, I know it's not y'all problem, but go ahead, I guess.
All right, well,
Nothing I
just
can do about it.
let me get through this and we can talk about some stuff, okay? All right, so 60 hours of community service. We can modify it to change, I guess, a portion of the fines and fees into community service is my understanding. But let's see if you do the first 60 hours of community service. A risk reduction program, a substance abuse evaluation, and any treatment that may be ordered. No alcohol or illicit drugs during the course of your probation, and you're subject to random screens for alcohol and drugs, and 1 AA meeting per week. Now, I did understand you to say that you had taken some courses, so present those to probation. If they have any questions about whether they're allowable, they'll bring them to me and ask about whether I'm willing to accept them, but go ahead and present them to your probation officer. Also, to run concurrent with that, meaning at the same time as is a fine, an additional fine in the amount of $200. So let's talk about it. So where are you?
Yeah, let's talk about it. You guys are mad at the wrong thing right now. I know what you're saying, but this is when you're gonna get angry. And I know the chat's gonna blow up with when she starts talking. Again, she's not disrespectful, she's not mean, but yeah, some might say she has a problem.
Okay, breathe. So are you here in Georgia or are you in Miami? What's going on?
I'm back and forth. I come. Yeah, because I don't really have a stable place to stay, so I have some work here. So I come here and work, and then I'll be back and forth with my mom and my kids. So, I mean, like, this is like years later, and it's coming to a point, it's at a point now that it has finally surfaced that I'm going through all these transitions and got all this going on. So it's really inconvenienced and messing up the quality of life for me right now, like the meetings and all this. And so it's like, and then y'all got like, I'm a drunk or alcoholic, like these classes, like I mean, I guess that's how it goes, but that's crazy. It wasn't like I was a radical driver or anything. I voluntarily went that way because I was fine going to get
Oh.
someone to go back home. But blood thing. I mean, the blood says different, but I get that
So-
part. But I mean, it's just a lot right now. It's just a lot, and I
Miss
don't want to
Aldridge?
violate being the fact that I'm here and I'm there. It's just a lot right
Miss
now.
Aldridge, stop. Okay, first of all, a lot of people think that they're fine when they've had some drinks, but a blood alcohol level of 1.21, and you don't look to be that big. So that's a lot of alcohol in your system. And so, no, you weren't fine. And just imagine if you
Yeah,
had picked
because I had to move. They sold our house while we was in there, and we had nowhere to go. So
ma'am,
I've been
I'm
going
not
through this for
talking about your
years.
house. I'm talking about your blood alcohol level. Listen to me.
Yeah,
We're
I'm
gonna
saying
get to
I was
that.
going to the store to get wine to go back to cope with my own self. It wasn't like I'm just driving the street drunk and erratically. You know what I'm saying? So all these classes, and it's just like crazy.
So, Miss Aldridge, you're still not accepting responsibility because you're saying
I
I was
accept
drunk
it.
and erratically. You got somebody's attention.
They stopped every car. You know what I'm saying? And I didn't feel like I was like no kind of way. So I just went through, but
You
I get
saying
it.
with a
The numbers
point-
don't lie.
Well, I'm just saying a 0.121 blood alcohol level, that's almost twice the legal limit. So you was just saying, because I was all right, I'm all right though. I could do it. And this is just causing me all kind of problems. Okay, let's get to
No,
what do you
I'm
do
not
for a
saying it like that. I'm not saying it
Okay,
like
Miss
that, but
what do you do for a living?
I bartend, I be at the Marriott, and I'm also a merchandiser. So I come in town and work with this company, and I'm back out of town. So I'm back and forth. I'm down there with my mom, helping my mom, and then I'm here trying to work to be back and forth to get a place. I don't even have a place, so I don't even know how I'm gonna do all this. You know what I'm saying? It's like I'm setting myself up to fail right now. You know what I'm saying? I just want this over, and it's coming years later where my life is category 5 right now. I mean, it's just a lot, but I just want this to be over.
Okay. Breathe. Okay, just breathe. All right. So
Yeah, just breathe. Do you remember the story that her attorney said? She was on her way to pick up her kids. That's what her defense attorney said. That was her excuse. She was on her way to pick up her kids. Now the story is completely changed. Now we find out that there was an open bottle of wine in the cup holder. Not a glass of wine, an open bottle of wine. As she was going to get wine, she had a 0.12, and I mean, they were pulling every car over on the road, so she just got unlucky, I guess. But she was fine. She was fine. I don't know how this judge takes this plea. I don't. I've seen Judge Simpson throw out these plea deals left and right when people talk like this. Not all judges do. And I don't, again, I'm not a lawyer. I don't know why some judges do and some judges don't. Might be a jurisdiction thing. I don't know. But yeah, she is taking zero accountability for this. And she's blaming the courts for messing up her life because this is what she decided to do. This is insane to me. I don't know if you guys are as upset as I am about this, but I'm upset about this.
the biggest thing is I understand what the situation is now. But the biggest thing is that you tell your probation officer if you're having difficulties. What I've said is whatever you've done already, they're going to consider that, okay? And if they can accept that, they will. So that'll be some of the stuff already done. The most important part is that you're working around alcohol, so that's kind of scary to me, but you're not to consume any alcohol or illicit drugs during the course of the 12 months. And you're to attend an AA meeting. Now, you keep saying how this is an inconvenience to you and all of that, but ma'am, a blood alcohol level of 0.21, it scares me that you're really not accepting, you're not accepting responsibility. You're not saying, hey, I made a mistake and I'm moving on and things have been rough since then. I get it. You're saying, yeah, I was good. And I stopped and they didn't stop me and I was good to go. I could have made it all the way home with my wine, which tells
I
me
mean,
that
I had my reasons at that time because we had to move and I had nowhere to go but back to Miami, something I didn't want to do. So I was going through a lot at that moment. our landlord sold our house while we were in it.
All
So
right.
it was just like we're homeless now. So I was going through something at that time. It wasn't like I'm just drinking and driving. But I mean, I get things happen. And I just I
Okay.
gotta, face the consequences right now.
Okay.
And it's just
So-
coming up at a time that, isn't good. I
Well,
understand I gotta
Okay. All right. All right. So just I'm gonna put you in a breakout room with Mr. Carmichael. He's gonna explain everything you need to know about probation. If there are any issues with you completing something for probation, then discuss that with Mr. Carmichael. He will help you to make he will help you to have the information necessary to make the decisions you need to make. I do say this though, the quickest way to get rearrested is to not report for probation. So you gotta report, okay? All right, I'm gonna put you in the
Okay.
breakout room with Mr. Carmichael. All right. All right, so Aldridge is done. That completes the arraignment calendar. Durden, on.
And on to the last one. And just like the one previous, I don't remember what the last one is. I don't. But yeah, that last one, I'm not happy about that. I'm not. So I'm not going to say anything else about it. Let's just watch the last one. But yeah, while I'm stopped, if you haven't done it already, please like and subscribe. It helps out the channel a lot. If you haven't done your backflips, jump kicks yet, please do those. You're going to have to work off that Halloween candy. And if you would like to donate, the links are in the description and floating around everywhere. All right, last clip. It's another like 10-minute one, so we're almost finished. You're getting through it.
All right, so we can call that.
Yeah, this is case number 23S18805FH, People v. Brianna Lipscomb. Ms. Lipscomb is present via Zoom. Her attorney, Mr. Franklin, is present in court. Today's date and time to address defense motion to withdraw as attorney.
All right, Mr. Franklin, go ahead.
Thank you, Your Honor. I have two motions before the court. There's a motion to withdraw. That's due to a breakdown in the relationship between my client and I. I'm also want to argue for a motion to forfeit the right to appointed counsel. So just to begin, the first part of the motion to withdraw. Normally, when I withdraw from a case, it would just be standard to let the court know there's been a breakdown in a relationship, and I typically wouldn't say much else beyond that. But in this particular case, from the onset of the relationship, my client began recording calls that were supposed to be confidential, email exchanges, and then there were assertions put before the district court that I had had no contact with Ms. Lipscomb. And in the same, well, in a different sentence or the same communication, I was let know that she recorded some of those conversations, which tells me that if I've never had
Hold on. We got a birthday. Nan, is it your birthday? If it's your birthday, happy birthday. That's awesome. I'm glad you're here hanging out with us. Happy birthday. I'm not going to sing for you. Don't worry. And I do apologize. This is the worst birthday gift ever, but you are going to see up her nose for the entire video. Just so you know already, just so you're aware. But happy birthday, man. Everyone say happy birthday to Nan. It's not a number, by the way.
contact with her, how could she record our conversations? So that's just untrue. And so the basis of this forfeiture motion, now a waiver, as the court knows, is a knowing and willing consensual relinquishment of a right, because the founders of this country, they did envision appointed counsel. They knew well the benefit of an appointed attorney, but they never envisioned compulsory counsel, which is why a person can waive many of the rights that the Constitution guarantees. They're not compelled to have them if they don't want them. Forfeiture is a little bit different. It's a knowing and willing engagement in conduct, knowing that engaging in that conduct in this particular case could bring about the loss of representation. That's a possible result. If the person acts a certain way. Accusing one's attorney of having no contact when I verifiably have over 22 contacts or communications with my client. Well, that's just part of being an officer of the court is you can't put a lie before the court. So I have to correct that. I've had robust communication with Ms. Lipscomb. I believe our very first conversation lasted over an hour and a half. But what Ms. Lipscomb has done is deliberately begin to fabricate a record, an adversarial record against myself, when initially there was no reason to do that. We just met, I was taking on her case. Yeah, she let me know that she's been recording these conversations to use them later, I'm guessing against me. So combine that with the inaccurate statement that I've had no contact with her. We've already covered that's not true. And
Yeah. NAN, I don't know what your name stands for. I don't know if they're your initials, but I'm a programmer by trade. And when you receive an NAN error, it means you try to input something that wasn't a number into a number category. So you get the not a number error, and it's NAN. So every time I see your name, that's what I think of. I don't know if that's what it means, but that's what I think of every time I see it. All right, let's go.
And it's not just that. It's that verifiably on social media, we can see that Ms. Lipscomb has recorded court staff. She's recorded Ms. Whitty, the prosecutor, and done all these other things and post these recordings on social media, which tends to frustrate my ability to present a defense. If she's putting out statements, these are statements of a party opponent that can later be used against her. But more than that, it shows that she is taking the court process, and what we see is in the district court, when it became time for trial, that's when the relationship really began to break down. I know in this particular case, there was Mr. Samuels as first the attorney. I remember him citing that there was a breakdown of relationship. I believe Ms. Lipscomb said that he had not had contact with her either. I don't know the status of the communication in that relationship. I wasn't privy to that, but that relationship broke down. Now she is on her second attorney, and I can tell you that it is broken down because I've had communication, but I'm being accused of not having communication. But it's not just two attorneys. So this case, she actually technically went through 3 attorneys. Before this case began, she had the chief public defender, Mr. Downs, representing her on a different case. She chose to record those conversations, which soured that relationship. Before this case even began, she had already burned through 1 attorney at the public defender's office. So there simply is no one else to represent Ms. Lipscomb. I can imagine no attorney who would find it acceptable to have their communications between their client, confidential communications, recorded and then put on social media. Not because the attorney fears that what they say is incorrect, but because it is completely contradictory to representing that client and helping them maintain the right to remain silent. So a change of attorney here, even though there really is no one else to appoint, is not, in my opinion, going to change her behavior. I had a similar hearing in the district court where it was insinuated that the legal decisions that I make are based on race, gender, and other protected classes. I can think of nothing more repulsive to me if that were even true. I spent a long time getting my law license. I went through a lot. There were many slippery rungs of that ladder that I had to climb. And it started in New York City, where it was hard just to get into law school for me. As I went through law school, I had to go through divorce, and that was also very difficult. I contemplated quitting, as many of my classmates did who went through similar situations. However, I didn't do that. I buckled down, I transferred to Michigan State, I came home, I lost my entire social network, I had no support, was in a tiny apartment, and I worked hard. Eventually, I would sit for the bar, I paid for it on my own dime, I passed it the first time, I didn't take a fancy course, I couldn't afford one. I studied on my own by candlelight some nights during the polar vortex. So I know well what the law requires of an attorney. And when someone says I'm not doing my due diligence, that hits me pretty hard. So I don't make decisions based on race or gender. If I'm ever mistaken, I'm absolutely open to being corrected, but I just find that notion to be repugnant and that accusation to be repugnant to my character. So I can tell the court what's probably going to happen here, which is the same types of things that are going to happen at the district court level. As this case gets closer to trial, even if the court were to find another attorney, I see Ms. Lipscomb is probably going to engage in the same type of adversarial behavior. As it gets close to trial, that relationship will break down. And what we see is repetitive conduct that frustrates the normal workings of the court. She has chosen to engage in this behavior. She chooses to record conversations. She chooses to post it on social media. She chose to accuse me of having no contact with her when verifiably I've had over 22 communications with her. She engaged in this conduct knowing it could lose her, this attorney, and it can also lose her under people for Cameron, the right to appointed counsel. She would still be free if the court grants my motion to procure counsel. It sounds like she's in the process of doing that. She's still free to represent herself. She's still free to take on a pro bono attorney. But as for the right to appointed counsel, I think her conduct and her abuse of her counsel has risen to the level where she has forfeited that right. And we know that the court can forfeit that. Before the attorney system was set in place in this county and other counties, courts would appoint attorneys on a contract system. And some individuals would go through more attorneys than others. And there usually comes a time when the court would say, without case law, look, if you can't make it nice with this attorney, you're not getting any more. And that's where we are with this case. So I would ask the court to grant my motion to withdraw because there's been a breakdown in relationship. And also, based on People v. Cameron, grant my request for the forfeiture of the right to appoint a counsel. So the court is no longer obligated to appoint the public defender services for Ms. Lipscomb in this particular case.
Ms. Lipscomb, do you have a?
All right. There were a lot of things that were said. I think Northwest is asking specifically to what he was pointing out about maybe a leaked audio file or something. We do. I don't think I believe he can hear it. I think he was asking about his comment earlier. And Nan, now that I'll call you Nan instead of NAN, the reason I said NAN is because the NAN error is a capital N, lowercase a, capital N, the way you have it spelled. So that's why I've always assumed that's what your name meant. But now that I know it's Nan, yes, that is a very common name for a grandma. So I get it now. It's just the way you have it lettered. Because I'm not going to say spelled. It's only 3 letters. But yeah, all right. Now we're going to get to hear from the star of the show. That was a very long speech for wanting to withdraw, right? That was long. He went into his whole life story, almost as if this is the very first time he's ever had to withdraw as an attorney before. But he put a lot of work into that speech. That was about a 5-minute speech on why he thinks that he should be granted his withdrawal. So now we get to hear from her. Enjoy, because it's fun.
Response, if any?
Yeah, I actually do have a response. What I'll say, one is speculation completely. Him saying that I'm recording for the reason of trying to get anyone in trouble or anything and stuff like that. There's no proof behind any of that. I've been recording because, like I told the courts from the beginning, I feel as if I've been lied on about a lot. And at this point, I feel the only thing I can do to really prove myself is record, because otherwise it becomes a lot of he say, she say, and then in these situations, I'm not really being believed for whatever reason. But I do know that video proof and that recording, that won't, that to me, that's things that it will, you know what I'm saying, I could use for that, and it's no longer versus just the he say, she say. And then what I would have liked to comment to as far as when I told the courts and them that I had no contact with him, it was me telling them that he has not contacted me by phone, because after court, he had mentioned that we will be in contact once a week and things like that. But during that time, previously, like he said, we did have that 1.5 hour long first initial meeting. And that's when he's referring to when I was recording the conversation and stuff. So that's how I was able to, recording things like that, due to the fact that we did have that 1 hour long conversation. But once his murder trial stuff had begun, every time, and I have the emails as well, as I'm pretty sure he hasn't to submit to you guys, every time it was time for us to meet and stuff or have a meeting, he would say something like, oh, I'm still in trial, or I'll call you later, or things like this. And then at that time, I'm not sure if they had the right number for me, because he was also told me like, oh, I tried to call you, but your voicemail's full. And I'm like, this is a brand new phone. There's no way that my voicemail is full. I don't even have a voicemail on this phone yet for my voicemail to be full. So that's kind of what I have to say to that aspect. But I feel a very important thing that he's failing to mention to the court is the fact that prior to this, when we had our initial conversation, he told me he believed he's possibly represented Tickle Properties, and if I ever felt any type of way about that I can let him know and he will withdraw. At the court, when I found out that the owner of Tickle Properties was not gonna be required to come to trial because of he was sick with cancer and stuff, I didn't feel comfortable with that, so I expressed that to him, and he basically was trying to defend Tickle Properties and stuff like that. And I let him know, like, hey, you know what? I don't think this is gonna work. Didn't you tell me at any point in time that if I didn't feel comfortable, you would withdraw? He was like, yeah, but we can still work this through, and I'll set your case up in a way to where you can get the lawsuits and the perjury and all this, but that's not what I was after. And I kept telling him, like, hey, what I'm after is, I just want my ESA animal. I really don't care for the lawsuits, the money, and everything else. And he's just like, well, at this point, I can't really help you with that. I'm just very good appeal, blah, 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 at the end of all this. And respectfully, that's just not what I wanted. So I understand what he's saying. It's been a, breakdown, but the breakdown started with him and me feeling as if he was defending Tickle Properties. And then I immediately told him, like, hey, I'm no longer comfortable with this. I feel you're not, looking at what's right for me anymore, and I don't want this. And then once I voiced that to him, that's when the more of our issues began, because as the case kept going on, I feel as if he wasn't doing what I was asking him to do. And he's like, oh, I'm sorry. He's like, oh, well, I'm only required to do so much by law, and you're asking me to lie, or you're asking me to do this, and that. And it's like, I'm literally, even as today, like, I can literally just ask a simple question and either I'm being ignored, or he's like, oh, well, let me figure this out by the uppers if I'm even able to answer that or assist you with this and stuff like that. So it's like, I understand, certain things that he doesn't feel comfortable doing or want to do and stuff like that. But, when you're what I feel my attorney, if I'm emailing you questions and things like that, and then you're not responding back to him, or you only answering certain things, or you're telling me like, oh, I don't have nothing further for you, but So, and then I'm telling you like, hey, well, I still have questions, and then it's just being ignored, and then finally I'm being brought up like, oh, you're angry, you're this, you're that. I'm being told that I'm the basic stereotypic angry Black woman and things like that, and it's like, no, I'm really not. All I'm trying to do is, have representation of my case that I feel is fair. And if you had anything to do with Tickle Properties, and these are the people who's making all these accusations against me, and then you're, I don't know. I felt very uncomfortable with the whole Tickle Properties thing with him. That was my whole complaint. And then once I voiced that, like I said, it just literally went downhill from there. It went downhill, and I mean fast. And then
Ms. Lipscomb, can I just put out Mr. Franklin in his motion?
All right. I don't know how I missed the Tickle Properties when I was first watching this, and I have not stopped laughing since. Tickle Property, yeah, KCC gets it. Tickle Properties, what a name for a company, right? There was another question I wanted to answer that I kept seeing coming up. I don't remember what it is now because I haven't stopped laughing in a minute. All right, but this is gonna be the last time I pause the video, so I'm leaving now. I'll still be in chat, but this is the last time I pause and sign off. I do want to say sorry. Every time you see this spinning wheel, my Bluetooth headphones kept dying throughout the day, and generally it never messed up the video, but for whatever reason it did today. So every time that happened, my Bluetooth was dying, and apparently it messed up the recording. So I'm sorry, not recording. That's not what I was doing. But yeah, I will make sure to fix that in the future. That's not a lag thing. Bruce, no, you stop talking. I'm gonna talk as much as I want to talk on my channel. You're lucky I like you, Bruce. Playing. All right. If you haven't already done it, like and subscribe. Join the Discord. It's in the link. It's in the description. Links are flying everywhere. If you want to donate, 6K, just hit 6K. Yay! But until next time, bye.
Has indicated to the court in writing that he has never worked for Tickle Properties. Never represented them.
Whoa, that's not the statement that he gave to me. And if you want, you can question him on that. But the statement that he gave to me is that he worked for a law firm and he believed that he may have represented them before. And if I ever felt uncomfortable about it in any way, that he will withdraw.
Well, did you read his motion?
No, I wasn't given the motion until like the Monday before, last Monday. Not yesterday, but like last Monday. And my mom's been working with our church family and stuff like that to give me a lawyer. So
he gave you the motion when?
On not this week Monday that just passed, but like last Monday.
Right. So you've had it about 8 days and you've not read it?
No, because my mom and my church family is trying to give me a lawyer, so I was gonna let the lawyer like read it and explain it to me. Because when I tried to, I just didn't understand nothing. Like I opened it and I literally did not understand a thing. And when I need counsel, I don't understand it. I'm sorry.
You didn't understand his motion, which is a written version of what he just said here this morning. And I just let you talk for about 10 minutes and you were countering everything that he said here this morning. So what don't you understand?
How he feels that I don't, like what I just said, how he feels that I don't deserve a counsel based on my attitude or things like that. And then he also just stated that I willingly knew or something, that it was basically like make it right with him or I have no other option. Like no one ever told me nothing like that. I didn't have no knowledge of none of that. Like, I mean, just a lot of it I kind of don't understand. Well, maybe I can say it's not I don't understand. Maybe I don't agree. So I'm not understanding. I'm having a hard time understanding because I don't agree with it. In my mind, when I'm trying to process it, I can't because I don't agree with it, maybe. I don't know.
So here's the thing, Ms. Lipscomb. You've indicated to the court several things here, but one of the latter ones here is the idea that you're going to hire your own attorney. Is that what I'm hearing?
Well, my mom and my church family, yes, they are speaking with Mr. Kirkhoff out of Grand Rapids, and I text Franklin earlier today. I didn't have none of the discovery or anything on this case, and he said he couldn't take my case without that. So once Mr. Franklin emailed me that, then I will presume he'll start my case today.
All right. So here's what I'm going to do based on what I am hearing here. There is no opposition to your motion to withdraw. I'm going to grant that. As it relates to the request for forfeiture of her right to counsel, I would note that because she is pursuing her own attorney, that maybe that is a moot issue at this time. Ms. Lipscomb, if you do not, in fact, hire somebody, then you're going to either be representing yourself or we'll have to cross the bridge about forfeiture in the future. Now, I will say this, Mr. Franklin has laid out a pretty detailed and logical request as it relates to current case law that maybe you have, in fact, forfeited your right to appointed counsel because of the way you have failed to work with 1, 2, 3 attorneys now, the actions that you're undertaking, in essence, it's your actions in failing to cooperate, and or even one could characterize what's been submitted by Mr. Franklin as antagonistic actions that could be the subject of this forfeiture again in the future. But I hope we don't have to go down that road. And hopefully, Ms. Lipscomb, you will get a attorney and they can represent you and you can go from there. However,
Yeah,
we do need
I'll
to
have
keep our
one.
case.
All right, I know I said I wasn't going to pause it again, but I did have one thing I wanted to say real quick. The guy in the bottom right corner, he should get time served for listening to this. He really should. All right, that's all I wanted to say because that was in my head and I wanted to say it earlier. So now I'm out.
On track. So do we have anything currently scheduled? Let's just look. And then where's this? She has that case in district court still, right?
So, yes, Your Honor, actually, as far as I know, on Friday, this past Friday, she failed to appear, and a bench warrant has been issued.
Oh, she's got a bench warrant. Okay.
She was in the hospital, so she is. in
Yeah, I
the
was about to
process
say,
of
we provided proof
providing
I was in the
documentation
hospital.
and getting
I
that
was
cleared up.
passed out
She did have
incoherent.
a justifiable reason not to be there.
So, well, that raises a couple things here. First, Mr. Franklin, why don't you, if you haven't already done so, just email all the discovery materials that you have to her so she can provide them to new counsel. As it relates to the district court, though, I'm a little confused there. Did this motion get heard there already?
It did.
So she does not have an attorney at district court.
She does not.
I have
Okay,
the same guy is. I'm sorry.
Our office was left for standby counsel for the trial.
Yeah. So at this point, I don't know whether, did you also ask the district court for the forfeiture?
And it was granted.
Oh, so you are not the attorney of record. Sure. All right. So Ms. Linscomb, you do have an outstanding bench warrant. Now, that's up to Judge Vogt how that gets handled and your documentation of being hospitalized, whether he accepts that or not. Those are all issues for the district court. They're not currently in front of me.
I
And so
understand.
you'll have to get there. It's probably something you want to talk to whoever your attorney is you're talking to now.
Well, the guy
Get that taken care of.
the guy in front of you said he was my stand-in and he was going to submit it to the courts and stuff. So I was going to let him handle that aspect of it if that was okay.
But that's why I'm trying to get this cleared up. If, as of last Friday, Judge Vogt allowed Mr. Franklin and that, i.e. the PD's office, to withdraw and granted their motion for forfeiture, they are not your attorney of record. They are not on standby. You're going to have to take care of the district court stuff on your own or through whoever you hire. That's what I was trying to get to the bottom of them. As it stands right now, it sounds like there's a valid bench warrant for your arrest. So you need to get that taken care of, or you're going to run the risk of being arrested on that warrant. Now, hopefully we have looked, do we have anything scheduled here for this case? So why don't we do this? Ms. Linscomb, I don't even have a docket date in 2 weeks. So I'm going to put this on for status conference on November 28th. That'll give you plenty of time then, if you're hiring an attorney, to discuss with them and give them the discovery materials and be present on the 28th at 8:30 a.m. with you and your counsel. If you don't have one, you're still going to need to be present so that we can keep our case moving forward. And that means either you're going to represent yourself or hire some other person that you are not yet talking to. But let's keep it on for the 28th of November at 8:30 a.m.
November
just so we know where we're at.
November 28th at 8:30 a.m.
Yeah, Mr. Butler.
Thank you.
Are you requesting her to be here in person?
Why are you requesting her to be here?
I think she ought to be here in person. There's allegations of her recording, particularly while on Zoom, and then also,
Well, I thought Mr. Franklin's allegations were recording your phone conversation serendipitously, like with the
Yeah,
with the recorder without your knowledge.
At the forfeiture hearing, she also made some statements that I jumped to the conclusion she might have been Facebook Living the entire proceeding.
Oh, all right. Well, Ms. Linscomb,
Well,
I'm
Your
not gonna
Honor, I would
require
like
that-
to speak
Ms.
to that.
Linscomb, hold on. I'm not interested in an explanation. What I'm going to do, I'm not going to require that you appear in person. You can appear remotely. You can appear in person if you like. just know that there are signs here, and it goes without saying, frankly, you cannot record court proceedings. There is an official transcript if you need to know what happened in the courtroom, okay? You can order a transcript.
How do I
and
order transcripts?
You contact the court recorder. So either for district court or circuit court, whatever proceeding that you're interested in getting a recording of, you contact the circuit court or the district court for their recorders and request it. There's a fee for that you'll have to pay, but you certainly are welcome to do that. But you cannot record court proceedings.
I have
Okay.
never and I will not. Thank you, Your Honor.
All right. If there's nothing else, that will conclude the matter.
Thank you. I'll prepare.
Thank you.
Thank you.